One of the fun things about doing these recordings is I get to choose the topic. I get to talk about what I want, and I can rant about something that I think is rantable. Is that a word, rantable? Well, you know what? It is now. It's my recording. I can say what I want. So here's what I'm going to rant about now. I'm going to rant about a problem, and may exist in other areas of law as well, and it probably does, but family law is my field, so I'm going to rant particularly about that. And it's when there's a law that's passed that is not going to be complied with, which is bad enough, but at the onset of it, when it's first enacted, rational people know it's never going to be complied with, but it sort of sits there on the books. And there are a number of examples of this in family law. And I'll give you one, the statute that was passed, I don't know, 15 some years ago maybe, requiring parties to a divorce to file medical history accounts. And after it was ignored for enough years, the legislature changed it in a way that pretty much watered it down to nothing, but guess what? It still exists, and guess what? It's still being ignored. But there are a number of other examples of it. But what brings this topic to mind now is the new relocation law that went into effect last July. And let me start by saying that in general, I think the law is an improvement over the prior law. It sort of hurts to say that because I was intimately involved in drafting that law along with the late attorney Judith Hardigo-Sanka from Racine. She and I worked on it for several years. Judy was the lead lawyer in the Kirkfleet case in, I think, 1991 or whatever, from Racine County. And she and I worked on terms of getting the law changed as a result of Kirkfleet. And that law has been in place for, 27, 28 years or something. It's worked pretty well, but it certainly could use some improvements. And by and large, the new law does. And just to give one example, it's always been problematic that the trigger between dealing with relocation, or used to be called removal, and a change in circumstances was a move of more than 150 miles from the other parent or moving across state lines. When we did the revision back in the early 90s, we tried to deal with it, and I think we were fairly unsuccessful. The problem is if you're going to move from, say, Beloit to Rockford, it may not affect how much the other parent sees the child. Similarly, if the law is 150 miles from the other parent, what if you already live 150 miles and you move again? You're moving more than 150 miles. It's just not an additional 150 miles. And it's that sort of problems in the prior law that the new law addresses. And I think there's a really good job of making the law clearer in terms of the relocation requirements, of when it has to be triggered, when you come under that law, and what the requirements are. In addition, the specifics of the law, I think, are well intended. My problem is they're impractical. And just give you an example. The law says that if a parent wants to relocate, that they have to file a relocation motion with the family court commissioner, and in that they have to include things like the date of the proposed relocation, the location of the new residence, the reason for the relocation, a proposed new parenting placement schedule if the relocation is granted, responsibilities for transportation of the child, allocation of costs that may be changed as a result of the relocation. All of those are good things. All of those things should be taken into account. My question is, in the real world, is that really going to happen? And I very well may be wrong about this. And maybe all relocation notices will include those, and will include those in the detail necessary for the court to make the appropriate orders and actions according to the statute. But you got to take into account something, which is that most actions in court today are involving two pro se litigants. And when you pass a statute requiring substantial information, great detail, and specificity in terms of all these. Are pro se's really going to do? I'm not sure lawyers are going to do this, but are pro se's going to do this? And if they don't, what are the courts going to do? Well, in theory, what the courts can do is dismiss a motion for relocation for failure to comply with the statute by providing all of the necessary information in sufficient detail for the other parent to determine whether or not to contest the relocation. I just got a feeling it's not going to happen in the real world. I think if it's a lawyer, it's very possible that a court could do that. But as I say, most of these cases are pro se's. And like it or not, courts grant great deference, bend over backwards, in fact, to help pro se's and to apply the laws loosely, and here's the key word, if at all, to what they do. And there's a reason for that. It's not just because the courts want to help pro se's because they can't afford lawyers. A lot of cases they can't. There are a lot of cases they can, but they'd rather use their money elsewhere. But it's more often, I feel, because if they do enforce these rules strictly, the losers are going to be the children. The kids are going to be hurt because it's important in most of these cases that the children know where they're going to be living and particularly where they're going to be going to school. In the real world, in my experience, these relocation, used to be called removal actions, seem to be always brought in June, July, and August, sometimes a week or two before school starts. And what you don't want to do is have kids start school in one place and then during the course of the year, even midterm, have to take them out and have them start school somewhere else. There's a significant loss in the learning curve for children that do that. We know of studies that show how much learning children lose during just the summer, and having to start one school and start the other is very difficult for children. So courts, I think, in these instances, are going to bend over backwards to take these requirements relatively loosely and give a lot of leniency in terms of parents who don't fully comply with everything the statute's intending to do. And maybe I'm wrong. It'd be nice if I am. Certainly been wrong before in my life. And it's very possible that people are going to read the statute. They're going to find forms that deal with it. The State Bar Systems book that my office publishes is going to be having new forms coming out, should be any day now, which are designed to comply with the statute. And maybe pro se's will come in with it completely filled out. I get a feeling it's not going to happen very much. That in a lot of cases, the problem isn't that these requirements aren't appropriate or that courts shouldn't apply them. It's that they're too much, I think, for a lot of pro se's to do, and as a result, I get a feeling it's going to be honored in the breach. The second area that bothers me is the statute sets up certain time requirements in terms of the legal process. The first is that the initial hearing is supposed to be held within 30 days of the motion being filed. If the respondent doesn't respond, agrees to the relocation, they work out a stipulation as a relocation, fine. If not, then a further hearing is supposed to be held within 60 days, and that is supposed to be a final hearing. Those hearings probably at the family court commissioner level. If there is a de novo brought after the family court commissioner level, then the final hearing before the trial court is supposed to be within 30 days after that. Yeah, really. I mean, who's kidding who here? I practice, my office is in Milwaukee County. About half our cases are in Milwaukee County. It can take 4 months to get a hearing date in front of our family court commissioner. And that's not uncommon. 3 months, we're feeling really good. We did great. We're going to get a hearing date in 30 days, and then if that initial hearing, another one in 60 days, pretrials in front of our family court. I'm talking about pretrials, not de novo hearings that are full evidentiary hearings. Just pretrials can take 60, 90 days. Get a trial date, 4 to 6 months if you're lucky, sometimes more. I haven't gone out and bought my 2020 calendar yet, but on the verge of doing it, coming up pretty soon. So these time limits are aspirational. They're really, really nice if they'd be followed. But one thing that is very common with our legislature, I presume legislatures everywhere, is they pass requirements telling trial courts what they ought to do and don't include any funding for the counties in order to do it. So there's nothing in this legislation that says, let's hire 2 new family court commissioners from Milwaukee County so they can comply with these time limits. Or let's hire another circuit court or 2 so that we can comply with these requirements. Instead, they just make it up. And so when you have a family court commissioner in Milwaukee County that has, 20 cases set on his or her calendar that day, this has priority over what? What gets bumped? Well, your child abuse and neglect cases ought to have priority. There are other emergency custody issues other than relocation. Those might have some priority. And where do the rest of them go, and what do we do? My guess is what's going to end up happening is that the courts are just going to pretty much ignore the time limits. And the way they'll do it is in a way to get parties to consent to it. So, you'll be at the hearing and happen to pro se's as well as lawyers, and the court's going to say, well, I know I'm supposed to set this within 60 days. I'm having a real hard time finding a time for it. Would you folks consent to 90 days or 120 days? And what are you going to say? No, I want you to have it on that time limit. And it's a good way of irritating the court, which is not what our goal is. So I think there's going to be a lot of times when it's just sort of honored in the breach, and nobody takes these time limits terribly seriously. It bothers me, both these things I've mentioned today, and maybe it's just that I'm an old timer, but to me, court orders and statutes ought to have a meaning. We don't say when the court makes an order that the parties are invited to do the following if you feel in the mood and you would like to do it. It says order. And then what happens when the orders aren't enforced? There are a number of examples of this in this field, to the extent that clients routinely ask their lawyers, is this a court order that the court takes seriously? Is this one the court doesn't take seriously? Do I really have to do this? And there are a number of times that lawyers say, that one you can ignore. This one is important. And we sort of end up picking and choosing. That's not the way it should work. If there's a court order, if there's a statutory requirement, it ought to be taken seriously, or don't do it. I might be wrong about both these things, as I said. Maybe participants will comply with the specifics. Maybe courts will find time in order to do it. But I get a feeling it's not really going to work that way. And as a result, I think it leads to a disrespect for what statutes and what court orders say. And if you disrespect it in one area and get away with it, people think they can disrespect this in another area as well. So I'd like to see more consistency in doing this. I suspect, and I have no basis for this other than a suspicion, that this statute was done by a committee, and the committee sat around and discussed what in an ideal world would work well. And yeah, this statute is great in an ideal world. Unfortunately, maybe fortunately, I'm not sure, we don't live in an ideal world. We live in a real world. In a real world, it's just not the way it works. And I wish that when these committees got together and discuss what a really good statute would be and how it would work in an ideal world, that someone would peep up and say, excuse me one second, but in the real world, this just isn't going to work, and let's be realistic and do a statute that reflects what reality is. For more on this, please read my article in an upcoming edition of the Wisconsin Law Journal. I've written about this in a little more, a few more examples. And also in terms of case law, I hope you'll subscribe to the Wisconsin Case Law Finder. It's a terrific resource.